Thanks for listening to this episode. Like and subscribe to our channel. Okay, so diving in, what immediately jumps out from these sources is this issue of jurisdiction. It seems the actual rules about where Bolsonaro should even be tried sort of changed midstream. Can you walk us through that?
Yeah, that's a major point of contention right from the start. So traditionally, when a president or another high official leaves office, their cases, if any, usually move from the Supreme Federal Court, the STF, down to the lower courts.
Okay, standard procedure.
Right. And we actually saw that happen in January 2023. About 10 cases involving Bolsonaro were sent down. But then things shifted. In March 2025, the STF held a vote, 7-4, and decided to keep jurisdiction over Bolsonaro's main coup-related case.
So they reversed their own previous stance.
Effectively, yes. It went against a rule they'd established back in 2018, which basically said these kinds of privileges end when the term ends.
Huh. So what was their reasoning for doing that? And maybe more importantly, how did people react?
Well, the official line from the STF majority, people like Justice Gilmar Mendes, was that they needed to combat procedural instability. They wanted to avoid this sobi desse, this kind of up and down shuffling of cases between courts.
Okay, so efficiency, stability.
And also, they said, to prevent defendants from, quote, manipulating jurisdiction, they argued it caused clear harm to getting investigations done. But this didn't land well with critics.
I can imagine.
Bolsonaro's defense team and a lot of legal analysts immediately called it casuismo, basically a tailor-made rule just for this situation. They argued it creates confusion, conflicting interpretations, and, crucially, could even invalidate any eventual verdict.
Did anyone on the court agree with that view?
Justice Elise Fox, in his dissent, definitely highlighted the inconsistency. He raised concerns very similar to the critics. So the key insight here for you is, when fundamental rules seem to shift during such a high-stakes case, it inevitably feeds perceptions of, well, political influence. Regardless of the court's stated reasons, it shakes confidence in legal certainty.
Right. That makes sense. Okay, building on that idea of shifting ground, let's talk about the person at the center of so much of this. Justice Alexandre de Moraes. The sources describe him as having vast powers. That sounds like an understatement.
It really is. His role is quite extraordinary. Very unusual in Brazilian legal history. He's essentially wearing multiple hats at once. He's a lead investigator for the January 8th coup probe. He's the rapporteur managing the case. And he's also acting as a judge.
Investigator and judge.
Yes. He's overseeing almost everything, stretching back to that initial fake news inquiry in 2019, right through to the current trial. Just to give you a scale of it, by January 2024, our sources say he'd issued something like over 6,000 orders just in the January 8th investigations alone.
Wow. That is a lot of power concentrated in one person. How do critics see this, especially thinking about, checks and balances?
Well, the main criticism is that this concentration of power goes against the spirit, if not the letter, of the juiz de garantias principle. That's the idea that the judge who investigates shouldn't be the same judge who presides over the trial.
Right, separation of roles.
Exactly. Now, the STF kind of exempted itself from fully applying this rule, even while upholding it for lower courts. This has led to pushback. For instance, Congresswoman Julia Zanata proposed a law specifically to force this separation at the STF level, citing complaints about it hindering the defense.
Oh, absolutely. To give you the full picture, his supporters view him as a vital bulwark against anti-democratic forces.
Yeah.
They see his decisive actions as necessary, given the crisis situation Brazil faced. The defense did challenge his impartiality formally, but the full STF bench rejected that challenge unanimously.
So the insight here is this tension. How do you balance the need for potentially decisive action in a crisis against those fundamental principles of judicial impartiality and, well, spreading the power around? It really shapes how the public views the fairness of the whole process.
Okay, so with Justice Moraes playing such a central role, let's look at who is actually hearing the case. You'd maybe expect the full Supreme Court, all 11 justices, but it's a smaller panel.
That's another really key point of contention, yes. In December 2023, the STF changed its internal rules. Resolution 59/2023, I think it was. This directed new criminal cases involving top officials, like former presidents, to these 5-judge panels or termas instead of the full 11-justice plenary court.
And the reason for that change was?
Efficiency. To speed things up, basically. To ease the workload on the full plenary court, which apparently had a pretty congested docket, and avoid cases dragging on.
Makes sense on the surface, but what's the defense's take on this, especially for a case this massive?
Well, Bolsonaro's team argues very strongly that a case like this former head of state coup allegations absolutely demands the attention of the full court, the plenary. They also point out, kind of awkwardly for the STF, that other defendants from the January 8th events were tried by the full plenary.
So there's an inconsistency argument there.
Exactly. And critics go further. They look at the specific panel handling Bolsonaro's case, the first panel, and see it as, let's say, highly unfavorable to him. It's presided over by Moraes, remember, and includes two justices appointed by President Lula Cristiano Zanin and Flavio Dino.
So potential bias concerns.
That's the allegation. Plus, a panel trial is generally faster. Critics suggest this increases the odds of a verdict before the 2026 elections. They label this venue shopping by the court, arguing it undermines the jury's the right to be tried by the proper impartial court established beforehand.
Right.
The takeaway is pretty clear. When procedural tweaks seem to strategically affect who tries a case and how fast, it inevitably raises questions about fairness and can really damage public trust in the judiciary.
Definitely. Okay, let's shift gears slightly. A core part of any fair trial is the defense's ability to actually, defend. Bolsonaro's lawyers keep saying their hands are tied. What's that about?
Yeah, they've consistently raised concerns about what they call suspento de defensa, essentially, that their ability to mount a defense is being improperly restricted.
How so? What specifically are they pointing to?
Two main things come up in the sources. First, limited access to the full evidence. They claim they're only getting selected excerpts of things like messages from seized phones, not the complete raw data. They argue this stops them from doing their own analysis or finding evidence that might help their client.
Okay, not seeing the whole picture. What's the second point?
The second is being barred from observing testimony from co-defendants in related parts of the investigation, these outros nucleos or other groups. They argue that crucial context and potentially contradictory statements are being kept from them, which violates their right to cross-examine and really understand the whole conspiracy charge.
That does sound like a serious obstacle. Have they taken any action on this?
They have. In March 2025, Bolsonaro's lawyers, along with others, actually filed a formal complaint with the OAB, the Brazilian Bar Association. They alleged investigators deliberately filtered evidence and gave them incomplete materials. They called it an attack on democracy, not just a problem for lawyers.
Strong words.
Very. They argue that international standards usually demand much broader access to evidence for the defense. So the insight here is pretty stark. If there are genuine doubts about whether the defense had a fair shot at seeing all the critical information that equality of arms principle, it fundamentally challenges the legitimacy of whatever verdict comes out.
Okay, let's talk about a key piece of evidence. The testimony of Lieutenant Colonel Mauro Cid, Bolsonaro's former aide. He seems central to the prosecution's case, but his plea deal is now under fire.
That's right. Cid's testimony, which came via a plea bargain, a delor-sem premiada, is absolutely crucial. He's the one who described alleged secret meetings and coup plotting details. But the defense has been attacking the reliability of this testimony and the deal itself.
On what grounds?
They point to what they claim are inconsistencies in Cid's story over time, and they've also released some private messages where Cid apparently suggested he felt pressured or maybe even misled when he gave his testimony. Based on this, in June 2025, Bolsonaro's team formally asked Justice Moraes to just throw out Cid's plea deal, arguing he'd lied.
And how did Moraes handle that request? Did he look into whether Cid lied?
No, he rejected the motion pretty quickly, calling it impertinent given the stage of the trial. Expert analysis we looked at suggests Moraes basically stuck to form, focusing on procedure rather than digging into the substance and the merits of whether Cid might have actually lied.
So he didn't engage with the core accusation?
Not directly at that point. This approach, sometimes called jurisprudencia defensiva, effectively makes Cid's testimony kind of untouchable for the moment, even if new facts emerge later casting doubt on it. August 13, 2025. During a hearing, Justice Moraes suspected a lawyer, Marcus Vinicius Figueiredo, who was representing one of the generals involved, might be secretly recording the proceedings. So Moraes ordered court security to inspect the lawyer's phone right then and there.
And was he recording?
No, turns out he wasn't. But the act itself sent shockwaves. Critics immediately pointed out that Brazilian law heavily protects lawyer communications and property. Doing something like that, they argued, undermines attorney-client privilege and creates a serious chilling effect. Lawyers might be afraid to represent their clients vigorously if they think their confidential materials could be seized like that.
Was this a one-off, or are there wider concerns about this kind of thing?
It's not entirely isolated. Concerns were also raised back in August 2023 when phones belonging to another Bolsonaro lawyer, Frederick Wassef, were seized. The Bar Association argued that search was illegal too, partly because their representative wasn't present and it wasn't tied to a crime the lawyer himself committed.
So a pattern of concern then.
It suggests a pattern, yes. The critical point for listeners is this. If that shield of attorney-client privilege seems permeable, it doesn't just affect one lawyer or one client. It raises fundamental questions about everyone's right to a fair defense and the independence of the legal profession itself in a democracy.
Okay. And bringing us right up to the present, just this month, August 5th, there was another big step. Bolsonaro was placed under house arrest.
That's the latest major development, yes. Justice Moraes issued the order, arguing Bolsonaro had violated his previous pretrial conditions. The specific claim was that Bolsonaro incited unrest by having his sons use their phones to project slogans like, "This is for our freedom," onto a screen at a rally. Moraes saw this as breaking a ban on Bolsonaro using social media.
How did the defense respond to that?
They strongly contested it. They argued it was just standard political speech, a rallying cry you'd hear anywhere, not a criminal act or a violation of the court's orders.
What about the conditions of the house arrest? Are there broader constitutional questions there?
There are. While Brazilian law, specifically Article 312 of the Criminal Procedure Code, does allow for home detention to ensure public order, legal scholars are raising red flags about proportionality here. Professor Vera Kemim, for example, warned that the conditions imposed like a sweeping ban on all communications essentially isolate a major public figure completely. She called it a potential mortal blow to freedom of speech.
And the specific conditions are quite strict.
Extremely strict, according to the sources. No walks outside, no media interviews, no smartphone use at all. It's unusually severe. So the core insight is navigating that tricky line. Where do legitimate court orders to prevent further violations end, and measures that look potentially excessive, maybe even politically motivated, begin? Getting that balance wrong risks eroding fundamental freedom.
So zooming out, what does all this mean beyond Brazil? You mentioned it's become an international issue.
Oh, definitely. This trial isn't happening in a vacuum. It's had significant international repercussions. For instance, remember that report about police finding a draft asylum request to Argentina's President Milei on Bolsonaro's phone? That was in August 2025. And before that, reports he'd briefly stayed at the Hungarian embassy.
Right, seeking refuge. What about other countries like the U.S.?
The U.S. reaction has been particularly notable. You had former President Trump publicly condemning the trial. Then, in July 2025, a really significant step. The U.S. Treasury sanctioned Justice Moraes himself under the Global Magnitsky Act, citing alleged human rights abuses related to this case.
Sanctioning a Supreme Court justice, that's huge.
It is. And the U.S. Embassy in Brazil apparently accused Moraes of persecuting Bolsonaro, which prompted Brazil to summon the U.S. Chargé d'Affaires, accusing them of interference.
How did Brazil's current government under Lula react to the U.S. actions?
President Lula strongly condemned it as unacceptable interference in Brazil's sovereign affairs. And domestically, figures like Justice Flávio Dino publicly supported Moraes. So you see this polarization mirrored internationally. Trump allies side with Bolsonaro. Lula's government defends Brazil's judiciary. Meanwhile, most democratic governments are sort of carefully emphasizing the rule of law, while human rights groups call for transparency and due process.
So it really illustrates how domestic legal battles can spill over.
Exactly. The big insight here is how a single, albeit high-profile domestic legal case, especially one pushing institutional boundaries, can become a major geopolitical flashpoint, tangled up with international relations, trade perceptions, and ultimately how the world views a country's democratic stability.
So pulling all these threads together, the jurisdiction shifts, Moraes' power, the panel decision, defense complaints, the witness issues, even the house arrest. And it really feels like Brazil's institutions themselves are on trial here.
That's a good way to put it. If you connect all these dots, the way this trial is being conducted and all these contentious legal maneuvers we've discussed, it stops being just about the outcome for one politician. It forces us, and you, the listener, to ask a really tough question.
Which is?
In the effort to hold a former leader accountable, which many see as vital, has Brazil's highest court maybe inadvertently strained or even sacrificed some of the very legal principles, impartiality, due process, predictability that it's meant to uphold? And if that's the case, what's the long-term cost? For democracy, for the economy, for public trust?
That is definitely a lot to mull over, and a situation that clearly warrants close watching. We really hope this deep dive has helped give you a clearer, maybe more nuanced picture of these incredibly complex and globally important events. Thanks for listening to this episode. If you enjoyed, like and subscribe to our channel. See you next time.